Hi, I'm Manny Fitzsimmons. I'm your Washington REALTORS Legal Hotline Lawyer, and this is another episode in our series discussing changes to the Washington Residential Landlord Act enacted through the 2025 legislative session. Those changes are already in effect, so what we're discussing today is current Washington law. Once again, we are fortunate to be joined by Jennifer Hohnstein, a lawyer with Williams Kastner in Seattle, specializing in property management, representing landlords, particularly in eviction actions. And our own Mary Hall Drury, director of our Government Affairs Department. So in this episode, Jennifer, let's talk about the exceptions to the rental cap limitation. So in the first episode, you described rent cap legislation that just took effect. So Washington law imposes rent caps on residential landlords. And I asked you at the end of that episode, are there any exceptions? And you said yes, and let's talk about it in another episode. So here we are. I want to talk about two things in this episode, and you can take them in any order. I want to talk about the exceptions, and I also want to talk about the notice form. I understand that there is a specific notice form. If you are a landlord and you are raising rents, it doesn't matter if you're raising rents on a single bedroom in your property, or if you are the manager of a 1,000-unit building, everybody uses the same notice form. Is that correct?
That is correct. If you have an exemption, you still need to use the form. You need to make sure that you indicate the amount of rent that's going to be increased, and you need to make sure that you're checking the correct box and providing the correct documentation about why you have that exemption.
Mary, where do they find the form?
So it's written in statute in House Bill 1217.
Which is going to become part of the Landlord-Tenant Act.
Correct, yes.
Which is RCW 5918, right?
Yep.
And none of us know yet which section that will be because we don't have it from the code revisor yet. Is that right?
That's correct.
And so to get the statutory notice, the only place they can go is to the bill language itself right now. Is that right?
Right. And we can link the bill language to this video as well.
And once again, the bill number is what?
House Bill 1217.
House Bill 1217. And so the language for the notice is embedded in that bill, which is now law. Everybody has to use that notice form.
Yes.
And there are some exemptions. So there are some landlords out there who can increase rent higher than the annual cap you described in the prior episode. Is that right?
That's correct.
Who are those? What are those exceptions? And maybe there will be some you don't give us, but primarily, what are the ones that the Washington Realtors membership is most likely to encounter?
The first one we normally see in new construction. If the dwelling unit has first had its certificate of occupancy issued within the last 12 years, the rent cap does not apply. So look back 12 years and you might be able to get exemption if it's a newer rental.
And so just to clarify, that's from the date of the certificate of occupancy until 12 years later, at which point during that 12-year period, there is that exemption. But anything after that, no
12
exemption.
12 years, one day after the first
Correct.
certificate of occupancy is issued, You're with the cap.
And it doesn't matter the type of structure, right? Could be single family, could be multifamily, could be duplex.
Correct.
So the first exemption we've discussed is for new construction, new being a broadly applied term anywhere within the first 12 years following issuance of the certificate of occupancy. Any other exceptions?
The next one is if the dwelling unit shares the kitchen or bathroom with the tenants. That too is exempt.
So the owner of the residence, the landlord,
yes,
shares the residence with a tenant. And part of the sharing of that residence means that either a bathroom or the kitchen is shared between the owner and the tenant. Is that correct?
Interestingly, it doesn't say that you have to share it. It says you live in a dwelling unit, which you share a bathroom or kitchen facility with the owner, and the owner maintains a principal residence at the residential real property. And so you have to live in a dwelling unit and other people have to share the kitchen or bathroom with you. So I think that there might be some type of exceptions, say you have a commune or some type of dorm arrangement where everyone's sharing the same kitchen or bathroom. That's when that would apply.
Oh, I gotcha.
Yes.
I had not contemplated that one. Okay.
Okay.
What else?
The next one is single family owner occupied residence in which the owner occupied rents or leases no more than 2 units or bedrooms. And that does include attached and detached ADUs.
Okay, so in this setting, we're talking about, I have a home, single family residence. I occupy, but I rent out 2 of the bedrooms in the home to other tenants, to 2 other people, my tenants. Or I have a single family residence and on my property, I have up to 2 ADUs. They can be attached ADUs or detached ADUs, either one. But as the property owner and landlord of the tenants in those other 2 units, I'm not subject to the rent control cap.
Correct. But again, you have to live in that residence. So you have to live there. It has to be your primary residence. And then if you have 2 bedrooms or 2 ADUs, the exception applies.
Okay. Owner occupied.
Owner occupied.
Residence with the 2 additional renters.
Yes.
In bedrooms or in ADUs.
Yes.
Okay.
But if you increase the rent, you still have to fill out that form, correct?
You always have to fill out forms.
Okay, so we've talked about 3 different exceptions so far. And Mary, what you just pointed out is even if you are exempt from the rent control cap, but you're going to increase rents, the only way you can increase rents is by delivering the statutorily required notice.
Yes, but there's one more exemption.
Okay, one more exemption.
Duplex, triplex, or fourplex. If you, the owner, lives in one of them and it's your primary residence, those 2 are not subject to the rent control bill, or rent cap, I should say. Again, you still have to send out the notice, but you're not subject to the rent cap.
Okay, so Jennifer just said, I'm sure it was clear enough the way she said it, but I'm going to repeat it anyway. You are an owner occupant in your duplex or in your triplex or in your fourplex. You are an owner occupant in one of those units, then you are not subject to the new rent cap legislation, meaning that you can increase your rents higher than what the cap would impose if you were not exempt, right?
Yes. And you still have to fill out the notice.
Okay, so let's talk about this notice. Jennifer, on this notice form, we announce what the new rental amount will be, correct?
Yes.
Okay. And we give a date for when the new rent goes into effect.
Yes.
Okay. And then we have to identify whether or not as a landlord we fall under one of the exemptions. Is that correct?
Then you have to check off whether or not you're raising it to cap, or whether or not you're going to claim an exemption and go above cap, or whether or not you're raising rent but will be below cap. So you have to check one of the boxes. And then if you're raising it above cap, you have to check which exemption applies to you. And in many cases, you have to attach the supporting documentation as well.
What would the supporting documentation be? Like a copy of my deed showing that I'm the owner of the single family residence with the 2 ADUs? Something like that?
Perhaps. Or, for example, the date the first certificate of occupancy was issued. And that way you could say, look, this is the first certificate of occupancy. It's within 12 years. The exemption applies.
Anything else with respect to the notice form or the exemptions that we need to talk about in this episode?
I think the most important thing is that landlords cannot use any creativity or deviations when going from the prescribed form, that it has to substantially comply with what the legislature has said. So I know that a lot of landlords have their own notices set up and like to present rent increases in separate ways. You can't do that anymore. You have to use the form provided by the legislature.
So Jennifer, is it as detailed as describing the font and the size of text that you have to use? I know that in some legislation where forms are prescribed, it does describe that. Does it describe that in this case?
I didn't see font and I didn't see font size. There are some language that appears to have to be bolded, but of course the standard is whatever you do, it must be legible. So please don't use 8-font single space. I don't think that anyone would be happy to read that, even if you're trying to save paper.
Landlords, if you increase rent delivering this notice, but you do so in such a way that a court that is hearing a challenge from a tenant says, wait a second, you did not substantially comply with the statutory requirement for this language because your font was too small, or you used some crazy font that we can't read, or you used white typeface on white paper, or something like that, right? Then all the creativity in the world is just going to land you in a mess where you have not effectively increased rent, and you've probably got a litigation challenge from a tenant.
It means that best case scenario, you have to lower rent until you've done it right. Worst case scenario, you're going to have to pay a lot of attorney fees as well as fines and other costs. So there's no good answer if a landlord decides to not use the form.
Okay, use the form.
Use the form.
In the next episode, we're going to talk about how and when you make delivery of the notice to increase rent. If you have questions between now and then regarding anything we've discussed or any other topic, please ask me a question by visiting warealtor.org and following the links to the Legal Hotline. Thank you for being a Washington REALTORS member.